My name is Jennifer Allmon, and I'm the Executive Director of a Texas Catholic Conference of Bishops, and I'm testifying in support of House Bill 748 and Senate Bill 835. The Texas bishops are committed to using all efforts to end the evil of child sexual abuse. Over the past 2 decades, the reforms within the Catholic Church have significantly strengthened child protection. The Catholic Church's publication of the names of clergy and religious who have been credibly accused of sexual abuse of a minor is a public statement that abuse in the church occurred, and it is also a statement of a commitment to prevent such abuse. These publications and these bills respect victim privacy while still rejecting secrecy. Catholic dioceses do not enter into settlements which bind parties to confidentiality clauses related to the occurrence of the abuse, unless the victim or survivor requests confidentiality for specific details related to the settlement. For example, when a victim says, "I don't want my grandmother to know I sued the church," then we will allow that type of a provision to protect the fact that there was a settlement. But because we publish the names, we never agree to secrecy of the abuse occurrence. These bills respect that approach and allow those type of confidentiality clauses without the secrecy clauses. I know there's been discussion over the various versions, and we just want to reiterate that we believe that the House Bill 748, is the more comprehensive approach. So it is our preferred approach because it covers agreements with both children and adults, and we think there's a value in that. However, the Senate bill we are still in support of because it is an incremental improvement over current law, which does not prohibit these agreements. And so both bills have our support, although the House bill is the more preferred comprehensive version.
Thank you, Ms. Allman. And let me ask you a couple of questions. And thank you for being here. And thank you for, I know you've worked with the authors on this bill and sponsor it. And thank you. And Senator Paxton asked a couple of questions of some of the witnesses this morning. Of course, this testimony is so important. I have a couple of practical procedural questions, if you don't mind, to give us a picture of how this works. And of course, I know you have a lot of education and training and experience, and you know, in lawsuits, and let me just zoom out, and we'll speak about lawsuits broadly. Not the subject matter here is just beyond heart-rending. But if we talk about lawsuits broadly, normally, when a lawsuit is settled, whether it's a lawsuit or a claim that someone has for an injury or for a breach of contract, when there's a settlement entered into, it's customary in most litigation for there to be an agreement. I'm not going to file suit, or I'll dismiss my suit, and confidentiality terms. Again, we're talking about lawsuits broadly, not these type of really, really exceptional cases. And so I think for many lawyers and for many people in the claims industry, it's just always assumed there will be a settlement agreement not to sue or to dismiss the suit, and confidentiality. It's just assumed those go together. We've learned from some things that you've shared and from other witnesses that that's not necessarily the case. And so if you'll give us a little more detail about that. So in the claims that the church is settling, so how does that work as whether confidentiality is sometimes negotiated for, never negotiated for? Just help us understand what that looks like. If you don't mind, we recognize this is very sensitive. We want to make sure we understand the process.
Right. Well, I'm not directly involved in any of these suits or discussions, but I work with all of the dioceses and the diocesan attorneys. And my understanding of our approach as from our safe environment coordinators as well as our diocesan attorneys is we never discuss or bring up confidentiality clauses or agreements. We don't say, well, if you wanted a clause, we could put one in, wink, wink. Like we don't mention the words. But often, not often, actually it's very rare, because I ask some of our attorneys, could you give me an example of a time where we did a confidentiality clause? It was very difficult for them to find an example because it is so very rare. But in the times when it has occurred, it is typically our most traumatized victims that request it. They're never gonna come to this microphone and tell you about it in public.
Right.
They know we're going to publish the names. They know we will send a letter to the parish to say this particular clergy person has a credible allegation of abuse, and they don't want anyone to ever figure out they were the victim. And so they will say, please keep my name out of publication. Now, we never publish the victim's name, but if they are asking us to please sign to keep their name out, we will do that to honor their voice and their request as a survivor. And so there are times where there's a request to make sure their name is never affiliated or associated with our publication, our parish letters, our public announcements. And then again, the example I gave in testimony, situations of abuse occur within families, and it occurs within churches, it occurs within schools, because predators look for any opportunity. And that's why we have all these do not hire bills. And I'm so grateful that y'all passed one off the floor today to close these loopholes so predators don't look for these differences. But as long as they exist, predators are going to exploit them. And so you sometimes have family members that are destroyed by this abuse because, the father or the brother or the mother is still close to the abuser and doesn't believe their child. And so there's an inter-family fight, and the victim says, I don't want mom to know that I signed this settlement because she doesn't believe the abuse and I don't want to get into that with her. Will you put this in? So it is the most traumatized victims who request a version of confidentiality. And our position is we will sign those types of confidentiality clauses as long as there is no secrecy clause. We will never sign saying that we cannot or they cannot disclose the abuser and the occurrence of the abuse. That is in the power of the survivor to choose whether they want to be associated with naming it. We will name the abuser because we made a public commitment in 2019 to always do that. And that is why on our website we have these publications. That in and of itself was a controversial decision at the time. At this point, many other faith denominations have followed that lead and are also publishing the names. And we think that's a part of the reform needed for pedophiles to understand they can't hide here. And this bill helps to deliver that message that we protect survivor privacy, but not secrecy for the abusers.
Thank you, Ms. Allmon. That's a very relevant distinction. Perhaps we've used the term confidentiality, or used other terms broadly, but I see what you're saying. If I got that right, there may be situations where the victim does not wish for their name to be released, but it sounds like in every case, the abuser, that there's never confidentiality there. Is that right?
That is correct. And that's why we appreciate the very careful wording of both bills to allow those provisions at the survivor's request for certain elements of privacy, but not for elements of secrecy. And the bills do a good job of that.
Thank you. Normally, we wait till our entire panel testifies, but while it was fresh, I wanted to make sure I understood that process that you've been through. Senator Paxton.
Thank you, Mr. Chairman. Those are really great questions, and thanks for answering those. So your confidentiality sounds to be exclusively focused on protecting the victim.
Correct.
You also described that it was that other denominations and religious organizations have started following suit, that it was controversial at the time. Mm-hmm. You created a real change in the culture around this issue.
We hope so, and we needed to do that as a part of our reparation for sins and crimes of the past.
Well, I think that's what we're really talking about at the center of these bills, is changing a culture. And I appreciate your language around, we're going to protect privacy, but we will not protect secrecy. And I especially love what you said, that you can't hide here. And I would hope that we as a state would take that position, meaning abusers, predators, perpetrators, that you can't hide here in Texas. Thank you.
Thank you.
And thank you, Senator Paxton. Senator Parker, you're recognized.
Thank you, Mr. Chairman. Jennifer, thank you very much for your testimony. And I know, as the chairman said, we're breaking out of our normal mode of hearing everybody first, but a lot to dive into here for a moment. So first of all, thank you for the church's leadership on this issue. And it's already been said by Senator Paxton, clarified by Senator Hughes. The focus, obviously, is not allowing these predatory monsters to hide with the structure that the church currently is employing. And I appreciate so much the bishops, the Catholic bishops in Texas standing behind us and passing this legislation and getting Trey's law accomplished. I want to also, though, get your thoughts beyond passing this bill in terms of the culture that Senator Paxton talked about. And I really appreciate your commentary about other denominations now are following the Catholic Church in this regard. What can the Catholic bishops do further to lead on this issue and to continue to, really kind of be a guiding light for all the other denominations? I mean, because let's be candid, so many of the things that we've heard today and have known have been organizations that, at least in some form or fashion, refer to themselves as being a religious organization, a Christian denomination in some form or fashion, a Christian associated organization, but yet their conduct has been anything but. So I guess what can the Catholic bishops do to continue to lead and be an example so that not only do we get the legislation passed here, but that we really continue to change the culture in Texas and across the country? How do we do that?
I think there's a couple of things, and we've been very active and involved over the last 6 years in all the past the trash bills and trying to close these loopholes. And I think the discussion today on the Senate floor shows that Texas is leading, that the place where I think Texas is doing the best job is in trying to make sure that we are sending that clear message that you can't hide here. The interagency database that allows all state agencies that serve vulnerable populations to search the do not hire lists of all other agencies has been a critical piece. But frankly, what I would like to see most out of the current stage of the process is full funding for these child abuse prevention efforts the state is passing. So it's wonderful to pass a bill like Senate Bill 1849 from last session that does that interagency database, but if it's not fully funded in its implementation, I still can't search that database. So it's great to pass the bill. We have to fund the FTEs needed for implementation of the bill. So the bill you passed off the floor today was going to require significant funding in the conference committee for the FTEs to investigate those claims. Increasing transparency around reporting is really important. We're about to get an increase in reports because of the legislation this body has filed. But if we don't give SBEC, State Board of Educator Certification, the investigators to investigate those claims, children will be abused. Adults will report because they know they need to, and no one will be there to investigate so that predator can continue to abuse. So to me, the biggest gap is the funding. And so I think in terms of a proactive approach, that's something we can lead on and call for the state to give that funding. I think in other ways, the Catholic Church is uniquely positioned because of our hierarchical structure. Today's a good day to talk about the hierarchy with the selection of a new pope. And that's not to say, what that means though is that the bishop and the pope can issue a decree and the church will do it. Other denominations do not have that structure, and so we can't fault them for being unable to make the level of systemic changes the Catholic Church can make because they have independent churches and they have autonomous pastors. And so there are a tremendous number of Baptist pastors, Lutheran pastors, Methodist pastors, who are doing really good work in this area. But it only takes one to have a problem for a super predator to thrive, because they don't have the hierarchical structure to say all Baptist churches are going to do this now. That's just not how their theology works. So our theology put us in a position to lead because the bishops in 2002 in Dallas signed the charter that all dioceses will do this, period, across the board, in unity. We have the structure that allows that. So I want to make sure that as I talk about the work we've done, that I know that other denominations and groups are doing tremendous work as well. But just like there are loopholes in the state system, there can be loopholes in the church. There was a bill passed a few sessions ago in the House, well, it passed both chambers, that's a really important legislation I don't think people always recognize that prevents liability lawsuits against churches who disclose abuse. And I think a lot of churches are not aware of that law. So better promulgation of that law was a bill by Scott Sanford back in 2019.
A pastor himself.
A pastor himself who, because of abuse he saw within Baptist churches, as a Baptist pastor, he was unable to report to other Baptist churches that there was a predator because he could be sued. And so it put a gap there. So y'all passed a bill that said you cannot be sued as a church, as a religious organization, as a private school for telling of abuse. if you have a credible allegation, a reasonable cause to believe, and you warn another employer that someone was dismissed from your employment, investigated, had a credible allegation, you cannot be sued for defamation. And that's really important. I think Texas has done a lot of reforms that people are not aware of that give churches tools to do better. And I think some better public education about those efforts would really help.
Oh, very good. Thank you. And your comments about the financial piece, good things that we've passed historically not being funded, I think is a very important takeaway for us to share with our colleagues, particularly as we're in conference here these final 10 days or so here at the budget. So thank you for sharing that, and we'll connect the dots. It's really enlightening and good feedback. One more topic broadly. If you wouldn't mind, when you have a situation with a predator and that needs to be addressed, obviously you talked about how their name is disclosed, all those things appropriately, which is great to bring sunlight to this darkness. What are the sequence, if you will, of events? Take us to the process when there's a concern about a predator, once it's been convicted, whatever, what are the processes when they're removed? And then at what point, do you turn them over to the authorities? Can you just kind of speak to that? Just kind of give us a high level of what that looks like within the Catholic Church today.
Sure. So when an allegation is made, every Catholic diocese has a victims assistance coordinator and a safe environment coordinator. It's often the same person. In larger dioceses, there might be two. And so an outcry is made. If it is made to a teacher in a private school or to an employee of a church, of a parish, then the person who receives that allegation first, all of our direction and policy is to report first to DFPS and law enforcement consistent with Chapter 261 of the Family Code within 48 hours. And so that report is made to those two locations. But we don't stop there because, unfortunately, oftentimes the follow-up doesn't happen, which is what I talked about in terms of the full funding.
Yes.
I'm not criticizing the investigators to say that the follow-up doesn't happen because they don't care. They don't have enough staff, they don't have enough personnel, and they can't do the investigation. So when we monitor and watch, if we don't get a follow-up phone call for further questions within 48 hours of our report, or within a set amount of time, I can't be certain on the time, but if we don't get a follow-up, we call back and say, no one has come out to the school to investigate, and we reported this, and no one has been here. And then they might
So it's a lack of staffing, so to speak.
lack of staffing. So
Wow.
law enforcement might say DFPS has to do their part first. They haven't done their part. We can't do our part. We'll call DFPS back and say, you need to get an investigator out there. We believe this allegation. We've removed this person from employment. We've removed them from contact with children, but they are in the community and they should not be. And we follow up and push, and we have had to do that in Texas more than once. And eventually, they do have the staff and come in and do the investigation and proceed. But we don't wait for conviction to remove. We remove at outcry. And so when the outcry occurs, the reporting occurs, the removal occurs, and then every diocese has a review board. The review board consists of social workers, psychologists, law enforcement, FBI, parents, a variety of well-trained people who know how to look at these cases. They review the allegation to make a recommendation to the bishop on the credibility of the allegation. And then the bishop, once that review board meets and presents that credibility, that's when their name is added to the list. Because we are not doing our own investigation. We are not law enforcement. We are not DFPS. That is the role of the state.
You turn it
will
over.
Always be.
Yeah.
We turn it over to the state. And we're very clear, no one should be reporting to the diocese an allegation if it has not been reported to the state first.
Yes.
Second, they need to tell us so we can remove them. So we're very clear in our training, and that training begins in 6th grade. We have safe environment programming for kids in our schools that are younger than 6th grade, but we don't talk as explicitly. We have anti-grooming training, but we are telling our kids starting in middle school, if someone has done something inappropriate, you tell. You tell us, you tell your parents, you can tell any adult at this school. And so that creates an environment of telling instead of an environment of secrecy. And so really, that's the beginning. I started at the point that the outcry gets up to the diocese, but really the beginning of our process is telling children to tell. And that starts in elementary school in terms of, feeling weird, but with more explicit detail in middle school.
Excellent. And my final question is, I guess, a simple one, but how do the Catholic Conference of Bishops feel about the first American Pope here this afternoon? What are they thinking?
We are thrilled with all popes at all times as good Catholics, but especially excited to have one of our own, and especially excited to have a Pope Leo XIV. I think the bishops are looking forward to what this new Pope will bring to our community.
And his leadership on this issue.
And his leadership on this issue, absolutely.
Thank you very much.
Certainly.
Thank you, Senator Parker. Senator Betancourt, Senator Birdwell, I did that for your benefit, Senator Birdwell. You gave me that look. Yeah, go ahead.
So, let me ask if I may. I need to broach the other end of this spectrum that's just as difficult to deal with, because we've seen the things that you've described and the manner in which you testified earlier about, secrecy versus confidentiality. How does the NDA, one of the Lord's 10 Commandments that's so, he said that there's a lot of important things, but here's the 10. And one of those is bearing false witness. Mm-hmm. How does both bills, affect the conduct of somebody that is falsely accused? And in entering an NDA, is that considered an admission of guilt? Because it's better to enter into the NDA than to go to court.
Mm-hmm. The way we approach that issue is that if a person has made an outcry and come to us, we consider that our responsibility of the church is to meet them where they are pastorally. Even if it's a false allegation, we listen, and if we don't believe them, we still provide them the pastoral support, counseling, and assistance needed for their situation. That allegation, if we do not deem it to be a credible allegation, would not result in a person being listed on our version of the Do Not Hire list, our clergy publication. And so that's the reason we do that National Review Board. I call it National Review Board because there's a national version as well, but the Diocesan Review Board is really the proper term in Texas. So the Diocesan Review Board is making sure this is not a false allegation. It's a credible allegation.
Is the NDA assumed to be a necessary tool because there's not enough evidence to pursue criminality? So this is all, I know obviously it's civil, but if you believe you have enough evidence that it's not just credible, but there is enough evidence to pursue criminality, is an NDA applicable in any way for something that would be criminal as opposed to civil?
I'm not sure I fully understand your question, but let me back up and try to respond, and then you can help guide me if I'm...
Well, because what I'm really driving to is I don't want the NDA to drive our jurisprudence from innocent till proven guilty to guilty till you prove your innocence.
Got it. As I've said, we don't use NDAs, and that's why we support this bill, because we don't believe the NDA is a tool to healing and restoration. And we take a restorative approach to all of these conversations, and we believe in restorative justice for both the victim and the accused.
Scripture was very
and that's
clear
really
about
the heart of what
restitution,
the point
so
is,
restorative,
right?
yeah.
So the decision of the church to provide therapy and counseling and financial assistance to a person who's come to us with an outcry is not necessarily saying we think this happened a specific way necessarily, but it's saying for this survivor, they are seeking this assistance from their church, and we want to walk with them and provide it. The question of criminality is a state question, and we have reported them. So the minute I can't say the minute, that's probably hyperbolic, but within that appropriate time period, within that 48 hours, we're making those reports, and we believe it is inappropriate for the church to determine criminality.
Well, I'm not asking you to determine criminality, because there's a separation of function. That's
Right.
God, the Lord gives Moses
Correct.
Administration, and he gives Aaron responsibility for the church. So there's a separation of function.
Right.
I'm supportive of where we're trying to go here. I'm just trying to make sure that that we don't end up inversing guilty till you prove your innocence, as opposed to innocent till proven guilty, even though that's a criminal standard as opposed to a civil standard, civil standards preponderance of the evidence. So I'm just, in listening to your discussion and how you're handling that, I'm just trying to make sure that even if it's a civil accusation, that it's
Properly
innocent-
vetted
innocent
and not
till-
just assumed guilty.
Yes,
And that's
ma'am.
why we
That's
have
what
the
I'm-
review board.
Yeah.
That's the purpose of the review board, is to take that, and the review board consists of experts who have the ability to make those judgments. That isn't the gift of the church to make those judgments. That's the gift of professionals, social workers, psychologists, law enforcement, FBI. They're the ones who evaluate the credibility of the claim and make a recommendation to us on their view. And we trust those recommendations because we value and trust their expertise.
Yeah.
And so in canon law, in the Catholic Church, we use canon law as our legislative guidelines. And in canon law, there's a provision about making sure that the bishop is always protecting the good name of a priest. And so when we made the decision on publication, that was a conversation, is that we are publishing the names of deceased individuals who cannot tell us, I didn't do that. And we're having to make the decision of, do we put this name on this list? And in our ecclesiastical approach to this, our theological approach to this, based on the body of evidence that we had, we believed the allegation, and we believed that the transparency for the survivors and the listing of the names so that survivors who had not yet come forward would do so knowing they would be believed was of value. And there were lawsuits against the church for the publication of names by people who believed their names didn't belong on that list. We won all of those lawsuits because of the ecclesiastical abstention doctrine, that the church could make that determination theologically to place those names there.
Right. Recognizing that you're speaking as a faith-based, religious-based organization, how do you think this would change for based on what you just said, a non-religious organization?
In terms of this bill,
Yeah.
I think this is a good bill for religious and non-religious organizations because it upholds the value of privacy and ends the value of secrecy that too many people, the misvalue of secrecy that too many people have had. And I think it's important that we take this step, and I think the families that have brought this bill forward have done so with the greatest of intention, and the content of the bill reflects the careful study. And we hope that it passes, and we're able to. We know from our experience, there's institutions who might be fearful of a bill like this, and our point is we know from our experience that this bill helps to restore victims. It brings about restorative justice and healing. It encourages talking and therapy and survivors getting back their voice, and that can't be bad for any institution.
Yeah, that's true. Thank you. Mr. Chairman, I do have another question, and since I missed this morning, what I'd like to do, I don't have questions for the panel, but I do have a question for Senator Paxton that I think you would be helpful as an attorney in helping answer the question, but I will defer it till this panel's done testifying, if I may do so.
Sir, that's fine with me. We'll be here, and so if you want to wait till after the witnesses, we can have that dialogue then. That's fine. So you'd
want me to ask-
you'd prefer to
you want me to
wait,
ask
or
it
do you
now,
care?
then?
It's up to you.
Okay, well, I was just trying to be courteous to the other four.
We can wait till after the witnesses. That's fine.
I'll do that, so.
Thank you, Senator Betancourt.
Thank you, Mr. Chairman. Jennifer, you've testified for both bills at this point. And the use of non-disclosure agreements has not been something the Catholic Church ever condoned, or at least in the Americas.
It has been the policy of the Catholic Church not to use non-disclosure agreements since the Dallas Charter in 2002. There may have been some non-disclosure agreements prior to 2002. We do not enforce those agreements since the Charter in 2002 when we banned their use.
Right. So, and that was an administrative decision following up on the comment, not a canon law decision.
Right. That was an and actually, it isn't. It is a decision the bishops chose to bind themselves to collectively, which is not traditionally how the Catholic Church operates. We have a pope, and not just today.
By habemus papam, I
Right.
believe. My Latin's a little rusty, but we have a pope.
We have a pope, and each bishop reports directly to that pope and not to each other.
Right.
And so each bishop can decide how they're going to handle these types of policies. But The bishops of the United States, beginning in 1986, began reform in this area, understanding that their previous approach was not as informed as they were becoming in the 80s and 90s. As the standard of practice on these cases changed, the bishops learned more. They started a reform process that was concluded in Dallas, Texas, nationally, and the bishops collectively, as a body, signed an agreement to hold one another accountable for compliance with the Dallas Charter. And so in that way, instead of it being up to each of the 16 dioceses of Texas to develop a policy,
Or the other diocese.
or the other dioceses of the United States, the dioceses of the United States have adopted this policy, and we have an outside accountability review by the John Jay College every year on how we're doing in complying with our policy, with our reporting, with our processes. And that's a very unusual step for the church to take, but it shows how important it was that we got the reform right.
It was a necessary step, especially at the
Necessary
time.
step.
Now, and during that process, was there ever any discussion of age on non-disclosure agreements? I'm just curious, because that seems to be the major difference
In the
at this
two
point in
bills.
time of the two bills.
I don't know, because I wasn't here during that time. I can tell you that our diocese today do not use non-disclosure agreements which bind parties on confidentiality of the abuser and occurrence
any
for
age.
any age.
Okay.
And that's why we can support both versions. And because our policy is that we don't do it on any age, we think that is appropriate for state law as well, and why we prefer the more comprehensive all-age approach.
Okay, thank you so much.